The last case for today is Jennifer Buhl versus the City of Oak Park. This is 20-minute arguments per side. And counsel, you may reserve some of that for rebuttal, but it's kind of up to you to try and do that. We wish you the best of luck, and you may proceed.
Thank you, Your Honor. May it please the court, CJ Schneider for the appellant. I'd like to try to at least reserve 5 minutes for rebuttal. Michigan law has a strong presumption that statutory amendments apply prospectively unless the legislature clearly manifests its intention for retroactive application. This rule exists because retroactive statutes present problems of unfairness by upsetting legitimate expectations and settled transactions. The requirement that the legislature clearly state its intention for retroactive application ensures that the legislature itself has determined that the benefits of retroactivity outweigh the potential harms. With these principles in mind, I turn to the 4 questions posed by the court. First, did the Court of Appeals err in holding that the January 2017 amendment applies retroactively? Yes. Under the 4 factors from In Re Certified Questions and LaFontaine, the 2017 amendment does not overcome the strong presumption against retroactivity. The first factor is the language of the amendment, and it carries the most weight. The 2017 amendment is silent regarding retroactivity, and it takes immediate effect. These 2 facts undermine any argument that the amendment was intended to apply retroactively. The legislature knows how to make clear its intention that a statute apply retroactively, and it did not do so here. This factor strongly favors prospective application. The second factor does not apply. The third factor outlines situations where retroactivity is not allowed. Factor 3 amendments include those that either take away or impair vested rights, or that attach a new disability with respect to transactions or considerations already passed. The 2017 amendment fits both of these categories because it adds a defense that completely bars Ms. Buhl's accrued cause of action. Accordingly, this factor favors prospective application. The fourth factor outlines situations where retroactivity is allowed. Factor 4 amendments are remedial or procedural amendments that do not destroy a vested right. The Court of Appeals majority here held that the 2017 amendment is remedial because it overruled Jones. But the amendment is not remedial because it affects Ms. Buhl's substantive rights by barring her accrued claim. As a result, this factor, and indeed all 4 of the factors, favor prospective application. The court's second question is whether the 2017 amendment attaches a new disability with respect to transactions or considerations passed. Yes, it does. This phrase refers to statutes that attach new legal consequences to events completed before the enactment of the statute. The amendment fits this definition because it adds a complete substantive defense to Ms. Buhl's claim after it accrued. Third, the court asked whether the Court of Appeals erred in creating a Brewer restoration rule. Yes. In holding an amendment prospective, Brewer noted that the amendment did not restore the prior state of the law. The Court of Appeals majority took this dicta from Brewer's Factor 1 analysis and turned its inverse into an absolute rule under Factor 4. Brewer does not contain or support the Brewer restoration rule. And besides, that rule is unworkable. It would require our courts to determine both what the status quo was and whether an amendment restored that status quo. That analysis becomes complicated and unworkable over the years as statutes are amended. For example, what if an amendment only partially restores a prior status quo, or restores it with different language? Or what if the legislature amends a statute so many times that it's not clear what the original status quo was? The Brewer restoration rule is not Michigan law, and it should not become Michigan law. Finally, this court asked whether the language in a civil action makes a difference. No, it doesn't. That phrase identifies the type of action in which the open and obvious defense is available. It does not fix the retroactivity analysis to the date plaintiff sued instead of the date that her claim accrued. The city's arguments to the contrary would create a race to the courthouse because a plaintiff who files even 1 day after she is injured risks complete dismissal based on a statutory defense added the day after her injury. Now, the city also contends that the phrase in a civil action rebuts the presumption of prospective application, but this is not the kind of clear manifestation required for retroactivity, as even the Court of Appeals majority in this case recognized. The strong presumption against retroactive statutes protects settled expectations, including the accrued claims of injured persons. As the late Justice Scalia observed, this doctrine is deeply rooted in our jurisprudence and is centuries older than our republic. The court should enforce it here and reverse the Court of Appeals. Thank you, and I'm happy to answer questions.
Thank you, Council. I'll start with Justice Kavanaugh.
She's NP.
Oh, I'm not going to start with Justice Kavanaugh. That would be weird. Justice Welch.
I have no questions. Thanks.
Justice Zahra.
Questions at this time, thank you.
Justice Viviano.
I have no questions either. Thank you, Counsel.
Justice Bernstein.
No questions.
Justice Clement.
No questions.
All right, Council, there are no questions for you at this time. Do you want to go on or reserve some time for rebuttal?
I'll reserve my 5 minutes for rebuttal, and thank you all.
Okay. Thank you. Mr. Huffman, you may proceed.
Thank you. Good afternoon, Chief Justice McCormack, Justices of the Court. Christian Huffman appearing on behalf of Defendant City of Oak Park. Before I begin, I'd like to state that I will waive any no fire zone that I may have. So if justices would like to interrupt me and go ahead and ask questions, that's fine. From my perspective, the language of the amendment certainly is broad enough to apply to lawsuits premised on accidents that occurred after the amendment, as well as accidents that occurred before the amendment. The legislature clearly stated that a civil action, in this context means any, and what plaintiff is asking this court to do is to rely on a non-statutory presumption premised on fairness and nothing in the statute itself to effectively amend the statute to add a restriction that the legislature did not. My stance is that it is improper for the court to do that in this instance because that non-statutory presumption dissipates based on presumptions that arise from statutory language. Within the GTLA, there are several provisions where the legislature has clearly said that it only wants that provision to apply to accidents happening after a certain date or lawsuits filed after a certain date. It's a well-known rule of statutory interpretation that if a legislature puts a restriction in one section of an act, but doesn't put it in another section, it's conclusively presumed that the legislature did not intend for that restriction to apply to the second provision. Also, the statutory history, and I'm not using the term legislative history, I'm talking about statutory history, shows that in 1999 PA 205, the legislature amended this very same statutory provision to add the 2-inch rule. And it used the same phrase, in a civil action. When the legislature amended the statute that time, it put it in the enacting legislation that amendment would only apply to lawsuits involving accidents that occurred after the effective date of the amendment. Since they did not do that this time, that shows that this time when they said in a civil action, they did not mean for it to be limited only to certain civil actions. So I don't think that the court can construe the statute the way that plaintiff is asking without rewriting the statute and doing it solely based on a non-statutory presumption. Also, as we've laid out, we believe that even in the absence of that, the amendment clearly is remedial in that it was intended by the legislature to basically abrogate this court's decisions in Jones versus Enertel. And the case law makes clear in recertified question and several other cases that where a statute is remedial, the presumption, the non-statutory presumption against retroactive application simply has no application. Aside from that, plaintiff actually admitted before the circuit court that the amendment is remedial because it was intended to overrule Jones. That's in the transcript at page 155A. And not only is it remedial, it does not affect a vested right. Plaintiff counsel used the term substantive right. From my reading of the case law, what the cases are talking about is, does it make a substantive change in the law that affects a vested right? Over time, when that has been summarized, the court has started using the phrase substantive, does it affect substantive right? I think what the cases are talking about is a distinction. Does it make a substantive change in the law that affects a vested right? It makes no substantive change in the law because the legislature is making clear it has always meant for the open and obvious doctrine to apply to claims brought under section 1402A. It intended that. That's the entire reason that section 1412 is in the statute or was in the GTLA. This court's decision in Jones versus Enertel effectively reads that section 1412 completely out of the GTLA because it can have no meaning unless it is read in pari materia with other provisions of the act. Not only is it not make a substantive change in the law, but it is my position it does not affect a right that is vested in the constitutional sense, in that we're dealing with a statutory claim that is purely statutory that can be done away with by the legislature at any time. Plaintiff had no reasonable reliance interest on the decision in Jones based upon the language of the statute as explained by this court in several cases, and also the fact that she already had regardless of whether the open and obvious doctrine applies, she had a legal duty to be aware of her surroundings, notice this danger, and avoid it.
Council, let me interrupt you and see what questions folks have, and if there are none, you can continue. Justice Welch?
No questions.
Justice Zahra?
The legislature put this, gave this provision immediate effect. What, if any, impact does that have on your analysis?
It has no impact. That doesn't provide any indication one way or the other. What does provide an indication is that when they have wanted it to have only prospective application, they've said in the enacting legislation, that's what they intend. Here, they didn't say one way or the other, immediate effect, retroactive effect, but we know because they did that in other provisions that here they didn't mean for it to have prospective only application.
Thank you.
Justice Viviano?
No questions. Thank you, counsel.
Justice Bernstein?
Hey, Council. Good afternoon and very happy New Year to you. So I understand your argument, but I guess where I'm a little confused is that this seems like it would be a sizable shift and a pretty substantive impact based on kind of the legislative conduct. And I mean, it's a little hard for me to kind of understand. Maybe you can try to convince me, but it's a little hard for me to understand that if this was going to be something that was going to be retroactive, that the legislature wouldn't simply make note of it. I mean, ultimately on a situation like this, where you're dealing with litigation, we're dealing with these types of issues, I mean, it's not something the legislature would just simply overlook. So help to challenge my perspective, if you could, to help me to understand how a situation that's as significant as this, in terms of its overall impact, the legislature wouldn't ultimately do what it could to try to be to be specific.
Yeah, I understand what you're asking, Justice Bernstein, but to me, it is the age-old adage of, could the legislature have expressed their intention better? Just because they could have expressed it better doesn't mean that they didn't express their intention. They said a civil action, which by its plain terms means any, and any is all inclusive. It means those pending now, those filed in the future, those filed in the past. And also you have the fact that on many instances in the past, when they have wanted it to be prospective, they have explicitly said it. So when they don't explicitly say we want it to be only prospective, that must mean that that the legislature meant what it said. A, which is a synonym for any, means every action.
Thank you, counsel.
Thank you.
Justice Clement,
No questions. Thank you.
are there any additional questions for Mr. Huffman? From anybody? All right, if you have time left if you want to continue. Mr. Huffman, if you have more to say, you can go right ahead.
Yes. I believe that is all I have for now.
Okay, well, thank you very
Thank
much. Mr. Schneider, you have 5 minutes that you reserved.
Thank you, Your Honor. I just want to address the question posed by Justice Zahra, the language immediate effect. So we would answer that question by saying there's a well-established rule that where the legislature is silent as to retroactivity and the statute provides that it takes immediate effect, that it is prospective only. I mean, that's most recently announced in this court's decision in LaFontaine. And of course, the legislature is presumed to know the law, including the LaFontaine case. So that language immediate effect would give textual support to prospective application here. Thank you.
Are there additional questions for Mr. Schneider from anybody? Okay, that just tells us that your briefing was really good. Thank you both. The case will be submitted. That will conclude today's call, and we will be back on the bench tomorrow morning at 9:30.